U.S. government. With that in mind, if you have not read this report, go get it. It's the OAG, Office of Attorney General in New York. They asked, I forget how many exchanges, I think it was 13 or 14 exchanges to fill out a survey. And it is one of the most eye-opening things that you should read if you're in the virtual currency space, if you're in the space of trying to understand what they call exchanges. We would not call them exchanges, perhaps. Platforms might be a better saying on it. It's just, I guess it's surprising to me, and again, I'm speaking for myself, my mouth dropped open a few times when I was reading it, because back in the 80s when I was trading currencies, there were a lot of things that were legal that you could do that are illegal right now. And what I would say is that's, to some extent, what I see happening on these exchanges right now is that you look at that and you compare it to the regulated exchanges and you go, holy smokes, I can't believe this is going on. This is fascinating. So I think, to me, as someone new into this space, to some extent, working for a regulator, I think it was just an eye-opener, and I hope everybody understands there's really big differences between different platforms, not only between platforms, but also just like pricing, maker-taker, getting paid for volume. I mean, it's astonishing what that does to price and price transparency. And really, just to bring this back home to regulators, I know that most people don't like them, and that's fine, but I will tell you this, like, trust is so important, right? And that's what the OAG report is about, is understanding that environment so you can trust a little bit better about what you're dealing with, who you're dealing with, and how you're dealing with them, how you trade on those exchanges. And to me, it's a little bit ironic, right, that here we are, we're talking about virtual currencies, which were developed because of a lack of trust in the fiat currencies, and yet it keeps coming back to trust. And that's what you'll hear, not only in the panels, but all through all the people that are out there on the floor talking about their new services. I think it just comes back to that.
I think you got a good point there, Andrew, that the SEC, the CFTC, are eager to understand and learn, and they've made a lot of developments in that area to talk about how they want to make sure that they put in best practices, and they really want to truly understand the marketplace. But John, you could probably give us some good insights on the report from the Attorney General, as well as your interactions with the SEC and FINRA on your digital asset working group.
Sure. And I usually had a strategy for. So the reason is this working? The reason that the regulators talk to me about exchanges is I used to be head of strategy for the New York Mercantile Exchange. So we as a Mike, turn it on. Is that better? Is that better? It's not working. Oh, here you go. All three. Try that. How about this? All three? Okay, great. So the reason the regulator, I think regulators both here in U.S. and Asia and elsewhere speak to me is I used to be head of strategy for the New York Mercantile Exchange, which at the time was the largest derivative exchange in the U.S., maybe the world, for commodities. So what's happening with the platforms, because they're not exchanges, is horrible. And it's horrible not because, we want to apply this old way of thinking to modern day exchanges. It's horrible because the elements that we're talking about are crucial to price discovery. So this notion that you can have an embedded or affiliated dealer desk that trades against your customers is incongruous with principles of price discovery. One of my jobs at the NYMEX was when every time the price of oil would spike, we'd get nasty letters from Congress who didn't understand what exchanges do. And they would say, do something to lower the price of oil. And we'd have to politely write letters saying, well, that's not what we do as a price discovery mechanism. You don't want us to care about price direction. That becomes harder to do if I've got $1 billion of crude oil futures on my balance sheet. So the notion that these platforms are trading against their customers makes them unreliable price discovery mechanisms. So the next generation of securities open exchange and a registered exchange should hopefully solve that problem.
And can I just add one thing? We're, from an agency standpoint, we're agnostic about a lot of this stuff. We don't play winners or losers at all. We want to foster thoughtful, responsible innovation. So to us, this tremendous energy in the space, we're excited for everybody who's in it, but we also, the trust is really important. So to your point, it's hard to trust people when you don't play by the same rules that the regulated exchanges are.
No, it's a very good point, and I want to turn to Manny and then I'll turn to Matt. But Manny, what are your views on the Attorney General's report on virtual markets? How do you see the space developing?
Sure. I guess you can hear me. That's a good sign. So yeah, the Attorney General report is surprising to me in a lot of respects, but not. I think there are, even the fact that there's some type of confusion about, and the SEC put out some clarifying language on this earlier in the year about what is an exchange, and you can't refer to yourself as an exchange if you're a platform, if you're not registered as an exchange. I think that is inherent and representative of the problem that we're facing, is that effectively we have a very complex situation of federal regulation from the SEC and the CFTC compounded with regulation from the states. So I think all in all, the regulation's out there, but depending on who you talk to, unfortunately, you get some misinformation, let's say. So when I read the AG report, I was not surprised. I think those reports, like that report, and any information that could be disseminated to the public are important to shed light on the fact that we really need to focus on what we could better do as an ecosystem, as a community, to improve things, right? So there's a lot of opaqueness in the market. There are a lot of things that are confusing and not clear. We need to work through those issues. The Congress of the United States Financial Services Committee had a roundtable a couple of weeks ago. The Financial Services Committee roundtable on regulating and uncertainty, which I participated in. I thought it was great. The CFTC has a technical advisory committee. So we have active engagement of the regulatory community. I think it's important for us to step up and meet the challenge, working with our regulators, working with our legislators in terms of really communicating and educating them in terms of what the issues are. With that being said, I also think we could work towards best practices. So there are a lot of things that were mentioned about price discovery, best execution. We clearly don't have a best execution obligation in crypto, but maybe we should consider that standard, and even if it's not a regulatory burden or regulatory obligation, maybe we should adopt it as a best practice, leading towards proactive regulation in the future. I'm a big individual who's supportive of very effective regulation, and I think we could move towards improving our processes and employing methods where we create what I'll call guide rails or lanes for having effective regulation. I think challenging that really doesn't help us. I think we need to work with the regulatory agencies.
Thanks, Manny. I appreciate the views as well. And remember, we have SEC perspective, CFTC perspective. We have John's views in dealing with FINRA as well, and we've got a former NASDAQ person, and also John formerly with NYMEX. So we have a broad perspective of regulatory. And we also have Matt, who could give us a little direction from maybe some of these non-U.S. jurisdictions, including SEMA, the Cayman Investment Monetary Authority. So,
can you hear me? Yeah. So I thought that the report was actually fantastic for us because for a few reasons. One is that it seemed to me to be one of the most cogent, detail-led pieces of information that's come out of any, it's not really a regulator, but any official organisation. Also, being in Cayman, a lot of people think that the reason to come to Cayman is because there's A, no tax, there's B, no regulation, and I can do what I like. And I'm definitely going to be dating myself here, but the days of the firm are long gone. And it's important for a lot of people to realise that whilst it makes sense to locate a business in Cayman, the operations of that business are often global, specifically in this space. And we are advising probably 5 or 6 people right now who want to set up crypto exchanges, platforms. John said he was going to jump across the stage if I said it was Cayman. And the problem is I'm telling them, listen, there's things you need to do. You need to worry about AML. You need to worry about whether or not you're being used for fraudulent activity. You need to worry about a lot of things in terms of the way in which you manage the workflows, the structuring. Are you custodying? Are you offering cold storage? Or are you just depositing? And often I get the retort, which is, you can't make me do this because if you do that, I'm going to be uncompetitive. Look at Binance. And then seeing the report, it's actually quite good to be able to say, listen, there are lots of exchanges that do some of the good things. There are lots of exchanges that don't do some of the good things. But this isn't about I can make you more competitive by coming offshore by avoiding regulation or the oversight of other organisations in the States.
I can appreciate that perspective because sometimes I talk to clients and they tell me, why is the U.S. so strict? We can go to Switzerland and Zug and we don't have to worry about any of this regulation. So I said, all right, let me look at some of those regulations, and I studied them. And sure enough, they say, there's very positive regulations for initial coin offerings, but there's a little, a couple sentences in the regulations that say if you market this initial coin offering as an investment, then you have to comply with the full body of all the securities regulations in Switzerland. So I think it's more of an understanding of the law than it is more, an application of rhetoric that maybe people are saying. So, Andrew, let me turn to you with another question. Is it fair to say that the CFTC has approved Bitcoin?
So we were involved in the self-certification process by which a Bitcoin contract for both the CME and CBOE were developed. We spent quite a bit of time with both of those exchanges developing that. As a matter of fact, if you want to learn more about that, we have a podcast called CFTC Talks. And we did something really unusual for a regulator. I know this is not super sexy stuff, but we had the division heads of all the groups that were involved at the agency come on the podcast and talk about how this came about. And I think from that standpoint, if there's other exchanges out there or platforms that are looking at doing something similar, you should listen to that. I'm kind of partial to it because I am the host. We're in about 100 different countries, 65,000 downloads, which isn't bad for a government podcast. But I think what's interesting is that we try to be as transparent as we can. I think, as I said before, we're agnostic when it comes to technology. We really want to help people in this context in our space. What can we aid them when they come to us with projects that they're involved with? To that extent, the chairman has been very clear about this, and we started a group called Lab CFTC. It's part of an overall regulatory framework in which we can have companies come in and take a look at our regulations. We can take a look at what they're doing and listen to what they're trying to accomplish. So it's a little bit of a regulatory sandbox. If you know what the FCA is and what they've done there, that's what we're modeling it onto. So I wouldn't say we approved anything. I mean, did we approve the corn contract? I mean, no, it's just something that's what we regulate. We take a look at it. It's important in the risk transfer markets that you develop these tools to help people, transfer risk that they don't want to have to people that want to have it. And that's really what we did.
And I think it's an important point that Bitcoin is not blockchain. Bitcoin is one of the use cases for blockchain.
Right.
Bitcoin currency trades on the blockchain, distributed ledger with technology. And both Chairman Giancarlo, CFTC Chairman Giancarlo, and Jay Clayton of the SEC have been very positive about blockchain, wanting to be modern regulators, understanding that technology exists, and they want to make sure that the people that are involved with it are complying with the rules. For example, with Section 5 of the 1933 Act, a federal regulation that deals with offerings. So if you're going to make an offering, whether you call it an ICO or a private placement, you have to follow either a registration or an exemption to registration. So there's very simple concepts. The SEC and the CFTC both feel they've spoken on this issue. John, we have a lot of clients that are involved with SEC examinations. And they are registered investment advisors in some cases, and sometimes they're exempt reporting advisors. With your dealings with the SEC, what do you see as the major issues for investment advisors or funds managing cryptocurrencies or digital assets?
So certainly the qualified custodial rule. I keep hearing people say, "Oh yeah, there are qualified custodians." I don't think there are qualified custodians, or at least there's nobody that the regulators have said we acknowledge as a qualified custodian. I think there are groups that can reasonably state we believe our processes and procedures and balance sheet and whatnot satisfy the rule, but this notion that that's a result, I see some of these groups with on their website saying we're a qualified custodian. We'll see how that all works out. Certainly we're moving in that direction. I mean, with ICE's launch of a physical deliverable futures contract, that issue is going to have to be solved. But the thing about qualified custodians is they let you know what their balance sheet looks like, because part of that process is the trust and security of usually a AAA credit rating. So when a qualified custodian or a firm says they're a qualified custodian and then they don't tell you what their balance sheet looks like, that's problematic. So I think qualified custodialship is the biggest issue. Obviously, best execution is problematic, depending on the nature of the type of exchange you're trading on. I think those are probably the two big ones. If you are a registered fund and you are transacting in primary market for cryptocurrencies, you are probably in violation of qualified custody. So now you can say, I'll wing it, we'll give it a shot. We don't think the SEC will close us down because they'll be okay with our policies we put in place to synthetically create that protection. But we'll see how it all works out.
You know, I would just add, there's a lot of discussion about talent moving offshore because of our regulations, and I understand that. You go where you can do your business and that you feel that's the best place for it. But ultimately, if you do that and then you can't get the trust that you want, or you lose custody funds, or you're not acting in a fiduciary manner, I mean, you're gonna have some problems.
And the problem with that is that if I'm going to go offshore, what does offshore mean? It means anywhere other than the States.
Certainly.
And then what are you going to do? You're going to ignore the second biggest economy in the world in terms of raising capital, in terms of where you want to sell the product, if it's having an ICO, whatever it is. You are going to have to negotiate the regulatory landscape here, and that's definitely the message we have to give people on a daily basis.
Andy, do you have anything to add on that point?
Yeah, so I agree, right? I mean, you can't run away from regulation. You have to face it and identify, what are the key issues. I think what's important is if you look at the issues that we're questioning right now, they're not very much different than issues we faced in the equities and options markets, 20, 25 years ago. So we do have a successful playbook. It's not 100% one-to-one, but there are a lot of similarities in terms of this market that we're in and how the equities, options, and futures markets matured over time in terms of the markets weren't connected. There was a lack of transparency. There was a lack of price discovery. We got there. We had some bumps. We took some bumps along the way, but we got there. So I think it's important to not forget lessons we learned from the past and what worked effectively. I also want to mention that when you look at the regulatory regime in the United States, I mean, they're using the tools that they have. So the SEC, they use the tools that they have, and the CFTC uses the tools that they have. So it's very understandable if you kind of look how things played out. It's not very surprising to me, understanding the securities laws on both sides from the CFTC and SEC, and even looking at the states in terms of some of the actions taken. Very understandable in terms of the actions they have taken. The question is, where do we go from here? Where do we want to be, and how do we bridge that gap?
And I just want to follow up on it because that's a great point. And the thing is like in the development of the equity markets and bond markets and so on, the regulatory agency did not lead, right? So if you're asking the CFTC that we need certainty, we need regulatory certainty, it's like, our chairman has said really clearly, like, we don't lead. The industry leads. Come up with your associations. Come up with the things that drive standards and standards of conduct. And we'll take a look at that and see what makes sense. So, I mean, I think that's just a really important point for people to understand. You have to drive it. Your industry, make the decision on where you want to go.
And Andrew, before you were a regulator with the CFTC, you were involved with the fiat markets. And what do you see as parallels between the FX markets when you were involved with trading compared to what they are with cryptocurrencies today?
Right. I mean, the similarities are hilarious. Back in the 80s when I was trading, 80s and 90s, I mean, it was, there's a great sign out there that says Wild West of crypto trading. Well, back in the 80s and 90s, we were trading. I mean, we're throwing tens of millions and billions of dollars around in a similar style market. I mean, there was a lot of regulatory capture, shall we say, there for people. And basically, at that time, it wasn't organized the way it is now. I think currencies back then were pretty wild, and there was a lot of similar things that you read in the AG report that were being done in the fiat world. So, and I just want to also point out that even in that space today, what are they trying to do? They're coming up with standards that people are supposed to follow, because it's similar in that you have the BIS, you have the central banks that do regulate banks and so on. But there's standards of conduct that people have to follow to engender that trust. Otherwise, you'll lose the people trading, and you'll lose participation, and then you won't have efficient markets. So I think it's the same thing that you can look at the virtual currency world, and really, and on top of that, I don't want to just get hammered in virtual currencies, because blockchain is so much bigger than that. Because you've got two different kind of spaces. You've got the permission blockchain, and of course you've got the decentralized consensus. So they're different things. So you don't always want to conflate the two. But that's what I see in the currency world. It's not like we haven't done this before. It's a little different. The tune's a little different, but it's very similar.
I totally agree. And John was able to articulate some of the SEC concerns for investment advisors earlier in terms of custody and valuation. And I think another one that the SEC is concerned about, in addition to best execution, is anti-money laundering, and how important it is to sort of combat anti-money laundering. And there's a whole group of regulators, OFAC and FinCEN, that are devoted to making sure that cryptocurrencies and fiat currencies are not used to launder money. And Matt, sometimes when we talk about money laundering, people think of these tax havens, and they say, well, the Cayman Islands is a tax haven. But what's interesting to me is that the Cayman Islands actually has one of the most burdensome and strict type of regulation with any anti-money laundering.
First things first, it's a tax-neutral jurisdiction. The other thing is that most of what we're talking about today, regardless of what aspect of it you're looking at, it's a terrible way to launder money. The other thing is, think about this. We get clients who say all the time, I can't believe you're making me do AML and KYC. And I say, well, we're not really. What we're doing is trying to imagine yourself as the analogy I gave earlier was a Chevy dealer. And the guy walks in off the street with 100,000 in cash, and he wants to buy a Chevy. Do you ask a question? Do you have to report that? Now in the US, you do. It's a cash transaction over $10,000. And yet people are thinking that they can sell products digitally, globally, in theory for sums much larger than that, without any aspect of querying where that has come from. And what I say to people is, listen, you're not, so let's leave security tokens offering securitized funds, all the real world regulatory stuff to one side, where you clearly do have to do all of that. Just ask a few questions. Is this a barista from Hoboken who wants to buy $100,000 worth of your token? Ask the question. You may have to then park that to a manual process, but if you've got, say, a securities lawyer from Manhattan who wants to buy $100,000 of your token, that's small chump change for him. But you don't have to then go further, maybe. So it's not. It's about simplifying it. And there are now some fantastic RegTech, FinTech solutions to allow you to do digital identity verification. You can then ask a few questions. You can do the sanctions screening. You can do the OFAC screening. So all of that comes as a sine qua non, I think, to whatever you're doing.
John, is another point?
So the working group I started, which is an attempt to distill best practices from the industry, push it back to regulators and get input, which has been great. We organized it in three sections. We organized valuation, AML, and custody. And I think for valuation and custody are solvable problems. You can solve those problems by throwing balance sheet at the issue. You can solve the valuation problem by full disclosure. They're solvable. They're tricky, especially for public index funds and ETFs, things like that, where retail's involved, but it's solvable through disclosure, through reasonable processes, and custodialship's solvable through balance sheet. AML, the rubber's going to meet the road at some point. Those who believe, and now we're talking not about blockchain, but about speculative cryptocurrency activity, those who believe in the principle of anonymity, one of the foundational principles of this entire asset class, will have to come to terms with the fact that that does not coincide with anti-money laundering as we currently know it, at least in the US. So there's going to be a lit and a dark market ultimately. There'll be a lit market where people will be okay with a centralized authority of some sort, knowing who they are, tying that account, tying that wallet to a definitive person that is trackable by a centralized authority. If you can't have proper AML without that. There'll be a dark market of people who don't, I don't mean to imply bad or good, but there'll be a market of people who say, no, I'm not going to abandon the principle of anonymity. They'll exist in a non-regulated market. But AML is unsolvable without that concept.
No, and I think it's an important point to highlight that the cryptocurrency and the money laundering are very difficult to do, as Matt was saying, because of the blockchain that keeps a dedicated and immutable record. And there are certain companies that have developed an analysis of the blockchain to highlight suspicious wallets. So while there's still some comfort in knowing that these transactions can be done where appropriate in an anonymous way, there's also a technology that can detect suspicious behavior. And that's the type of technology I think the regulators will probably implement, very similar to the way the SEC implemented Midas. And Midas was this, the sort of cure to how to make sure manipulation doesn't happen in our markets with traders that might be spoofing the market or entering trades of layering. So I think that the modern SEC is going to sort of develop more tools similar to what they've done with Midas, and to make this a better ecosystem, as Manny said. So, Manny, you mentioned state laws, and that's an important point because so far we've been talking about a lot of federal regulation and non-U.S. regulation as it applies to this space, but the states are very unique. New York has a bit license that may or may not be around for too much longer. Wyoming is a state that has a free reign of some sort with the cryptocurrencies. Providence, Rhode Island is another one that has come out and said that we want to be crypto friendly. Manny, what are your thoughts on the state regulations as it applies to this space?
That's a great question. The state regulations are challenging, right? Insofar as that, as you mentioned, you not only have to look at the federal landscape, but you have to look at each of the states have their own respective requirements. So you have to look at the requirements of the state you're domiciled in and of the states where your clients are domiciled in potentially. So you can't look at it just introspectively. You need to look on the outside in terms of who am I dealing with and where do they reside. Each state has their own regime set up. So you potentially need to get, for example, in New York, they have a virtual currency license, a BIT license, which has probably been around the longest, focusing on cryptocurrency. But on the other hand, other states have MTL requirements, money transmitter license requirements, which have been around for quite some time. People don't seem to remember, but kind of like the old Western Union where you wire money, those trigger the MTL licensing. Beyond that, you have the MSB, Money Service Bureau requirement with FINRA. So what I wanted to add to the comments that were mentioned earlier were that the governmental actors are not looking at this in silos. What I'm very impressed with is there's tremendous communication amongst the governmental regulators. So you get a matter that might be referred to the SEC from FinCEN or OFAC, or you'll get United States attorneys from various jurisdictions involved as well. So this is a concerted effort. All this activity is being monitored. The technology does exist to do chain analyses, for example. Not only on the cash side, we're talking about the actual crypto. So, you need to take that into account and realize that unlike a fragmented, regulatory regime that we might have had in the past, I think this is a very unique time because it seems like all the governmental agencies are acting cooperatively, and FinCEN, the head of FinCEN actually was at a panel on RegTech in Chicago a couple of months ago and mentioned the actions that FinCEN has taken, individually as an organization and cooperatively making referrals to other agencies with regard to AML. So, they are really focused on this in terms of looking at any kind of suspicious activity, they're on it and they will make referrals, and they have made referrals.
Yeah, so the cross referrals is a common way that enforcement takes place, whether it's the SEC referring to the CFTC, FINRA referring to the SEC. So there's definitely a joint approach there. So in the final minutes that we have about 3 minutes. I think I want to start and just ask John and go down the line and ask one question. There's been discussions in the past about having one sole regulator responsible for digital assets, cryptocurrencies. What's your theory or your thought about whether that's going to happen? A sole regulator for the digital asset space?
I mean, if it happens, that means we've failed, because that means that the use cases for this technology are so simplistic that could be pulled in under one regulator. So I think that would be if all Bitcoin ever is a digital store of value a la gold, then yeah, it gets shunted to the CFTC and life moves on, and all this transformation everybody's betting on is never going to happen. So I hope for the sake of the industry that doesn't happen, and I'll move on because you're pointing to your watch. You're very subtle there.
Do you want me to answer? Okay, I would just say it's hard to believe that would be the case because of what John just said. I mean, go read the SEC Commissioner Hinman's speech from the summer about ICOs and things like that. It's worth your while. It's the use case, right? If it's used as a commodity, if it's used as a currency that comes under the CEA, well, we're going to regulate it, and the SEC is not. If it's a security, they're going to regulate it. So I mean, I just don't see it. There is a tremendous, thank you, Manny, for saying this. I mean, like, people don't know, but these agencies are all talking like crazy. We all have to, because it's such a green field. We're all trying to learn, and by the way, that's part of my role here, is just to go out and talk to as many people, so feel free to come up to me. Don't worry, I'm not part of enforcement. You don't need your lawyer. But we're all just trying to learn, so I just want to say thanks in advance.
And the CFT does have some great educational outreach that Andrew's actually championed while he's been there. So in 30 seconds, single regulator, yes or no?
I agree with John, and don't forget there is a big wide world out there, and this isn't about regulating a specific item or product. This is we're moving into other things. This is simply a method of delivery. Whether or not you're trading a share or a token or whatever it is, because you might say to someone in the States, oh, well, digital fiat. So, oh, don't worry, I've already got PayPal. I said, well, what does the guy in Kenya think about that? He wants to use M-Pesa or BitPesa. And what's happening in China is something different as well. So it's a global environment. Government should give better guidance by implementing better laws. And so if you look, for example, in Europe at the 5th Money Laundering Directive, virtual currency exchanges are going to be explicitly regulated between fiat and virtual. And that's a good thing.
I hope this still works. We didn't bore you. You guys are still awake. No, from my perspective, I don't think we need another regulator. I think we have enough regulators. I think, again, there's discussion about another regulator, maybe because we don't like what the existing regulators are telling us. So again, I'll say it again, you cannot run away from regulation. I think we need to kind of work with the regulators, and potentially there could be clarifications from the regulatory community, FAQs, frequently asked questions, interpretive guidance, but I think we're up to our ears of regulation, so no additional regulator from my perspective.
Okay, well said. All right, gentlemen, we've finished our time, and thank you very much. Thank you.